circumstances in this case, including the information I've provided in my memorandum with attachments, I don't believe a probationary sentence is appropriate for this 81-year-old defendant in light of his condition, the fact that he lives in California, the fact that he's not a danger to the public, as I try to point out. And I'll go through those factors briefly. Your Honor is aware that the crime occurred in conjunction with a celebrity photo shoot at a convention in Cherry Hill, where Mr. Busey was posing with interested individuals and having pictures taken with them. Judge, we acknowledge under NJ2C 44-1A to a lesser or greater extent, and we're suggesting to a lesser extent, that factors 3 and 9 are applicable. Deterrence, I suggested most of my sentencing memoranda to courts is always somewhat applicable, but in this case, specific deterrence, I don't think is a heavy factor because I don't think Mr. Busey, under all these circumstances, is at risk of committing another criminal act in his life. Getting to the mitigating factors in 2C 44-1B, I asked the court in my memorandum to find as factors 1, 2, 7, 8, and 9 have application to the case. Although he doesn't have an unblemished prior record, he has led a law-abiding life for a significant period of time. And it is unlikely that the confluence of factors that led to the instant offense will emerge again. I say that, Judge, because he's not, his mobility and he spends a lot of his time at home with family, and he's not actively pursuing, at this juncture, to my knowledge, any type of commercial ventures in which he's seeking to have his photographs taken with people. That was a circumstance that presented himself with an unfortunate consequence. Under the circumstances, I asked the court to find that the mitigating factors outweigh the aggravating factors, and the sentence sought by the state in the plea agreement, which we've agreed to, is a probationary period. I asked the court to sentence on the basis of the facts of the crime pled guilty to, which is to be specific, a touching of the buttocks of an adult female over her clothing. And again, I'm not minimizing the fact that there is a victim here, Judge, but I'm simply trying to explain to the court our perception of the nature and degree of the harm inflicted on the victim. I'm not saying no harm was inflicted. I'm saying it was not substantial to the degree necessary that Mr. Busey has to be supervised. Your Honor, make brief reference. I attached as exhibits a report from Dr. Daniel Heyman, a substantial report which was produced in 2018 in advance of, prior to the commission of the instant offense. And that particular evaluation was done by Dr. Heyman, who has pointed out in his report, is a certified neurologist and psychiatrist. He notes that in 1978, 1988, Mr. Busey sustained a severe brain injury in a motor vehicle accident where he had no helmet. He was, as a result of that accident, left in a coma for 30 days. had to learn to talk, speak, and function again, with which great effort he's been able to accomplish. And certainly there's been no suggestion by law enforcement, by any medical doctor, or anyone, that he's not competent in a manner to deal with this legal issue against him. And again, I reiterate, for purposes of the record, I have no doubt, based upon my continuing conversations with him, that he's competent to have entered a guilty plea and be sentenced today. Medically speaking, he had a cancerous tumor removed from his sinus in 1997. So he's not been without serious medical injuries. And according to the doctor, Your Honor used certain language, but he does have mild cognitive impairment, which is, and early dementia, which, again, the court can take judicial notice that having the luck, good fortune, and good health to live to be 80 years old or older, there's going to be a diminution to some extent in cognitive skills. But again, he's competent and knows what he's doing, knows what's happening today, and is asking the court to impose financial sanctions only. Again, it's traumatic brain injury. I don't want to get technical, but as the doctor says in his report, the injury affects prefrontal cortex and temporal lobes bilaterally, and there were known to be clear cognitive deficits in focus and memory. Again, I don't want to confuse this with someone who needs attention, needs some type of support, needs someone around him to act independently and does act independently. He has a hearing problem also, and many people in their 70s and 80s have that. I'm beginning to get a hearing problem. So under all those circumstances, without minimizing, he does live in California. His elder son lives with him on most occasions, and he's resided there for many years. He has no ties to New Jersey other than his visit in 2022. I might add, since that the case has been delayed for various reasons having nothing to do with the court or defense counsel, in that we're in 2025 now, but during that period of time, the 3 years, Mr. Busey has not engaged in any behavior that would indicate he needs any type of probationary supervision. So again, I haven't spoken much about Mr. Busey's life, but he is obviously a recognized public figure, has had substantial success in the acting industry, is a well-known individual, and unfortunately, because of that, I'm sure he would not want to give up any of his public persona, but he has engaged. One of the deterrences for someone like Mr. Busey is the substantial adverse publicity that attends to being in a proceeding like this. To me, that's a measurable penalty also, and I think it factors into the suggestion that he will not violate the law again. So under all those circumstances, Judge, I appreciate the court for its indulgence all along this case by permitting Mr. Busey to remain in California, and I ask the court to consider no probation and financial penalties only. Thank you.
That's Busey's attorney trying to keep him off probation. The fourth-degree criminal sexual contact comes with either probation and a fine, or one or the other. Now, they went to break right after this morning's session and then resumed sentencing proceedings at around 3:30 this afternoon. I want to head back in now for some of the judge's remarks.
We'll begin with the state. Your appearance, please.
Assistant Prosecutor Brian Scanlon, on behalf of
Your Honor, Blair R. Zwillman, Morristown, New Jersey, for Mr. Busey, who appears remotely with the court's permission.
Okay. During the state, you had moved for sentencing, asking for no contact with the identified victim, correct?
That's correct, Your Honor. Moving for sentence in accordance with negotiated plea.
Now, Mr. Zwillman, do you wish to supplement the record from this morning?
Judge, what I stated before is of record now, so I don't have to repeat that.
Yes.
Yeah, as to the judge, based on that, and my position that Mr. Busey understands everything that's going on, has been of assistance to me, and has assisted me in his defense, Judge. I'd submit on the basis of what I've provided to the court in my sentencing memorandum, my earlier argument today. Judge, underlining the fact that under all the circumstances, a probationary sentence is not necessary. Thank you.
Thank you. Okay, Mr. Busey.
Yes, ma'am.
You have a right to speak at your sentencing. Do you want to say anything, sir?
I'm following my attorney's advice.
Okay, and what I want to say to you is, you have a right to say something if you would like to. Do you want to say anything?
No, ma'am. I'm fine. Thank you.
Thank you. Okay. With that, the court makes the following finding. I do want to state for the record that based on the submissions that were presented to the court in a letter brief back in September 1st, this court had additional concerns. The court continued the matter until 3:30 this afternoon. So,
All right, we're going to step aside here and take a break. When we come back, we're going to get you back for more of the sentencing for actor Gary Busey. Keep it right here, your front row seat to justice.
My two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Ted Martell ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands, a Court TV original series. Season premieres September 27th.
Only on Court TV.
We want to head back to New Jersey now for more in the sentencing hearing for actor Gary Busey. In his sex charges case, Busey has pleaded guilty to fourth-degree criminal sexual contact. He's facing up to 5 years probation and a $500 fine. His attorneys are seeking to have him only to be fined with no probation. But prosecutors are asking for probation, so let's get back into court.
Defense counsel could provide the court with a supplemental medical report. And I do note that in looking at that supplemental report from Dr. Amen, and that's Dr. Daniel G. Amen, when I looked at the original diagnosis from that doctor, which was a letter dated April 25th, dated April 12th, 2013, that caused this court concern. That concern has been satisfied. Dr. Amen has written a supplemental letter stating that Mr. Busey is competent to proceed today. So therefore, the court will continue with his sentence. With that, I make the following finding. This defendant is 81 years of age. He pled guilty to count 1 under indictment 338-0225 Count 1 charges the defendant with fourth-degree criminal sexual contact. This plea results from an agreement with the prosecutor. Defendant waives his right to appeal. I have had the opportunity to review the criminal division's pre-sentence report, and I find that this defendant has had prior contact with the criminal justice system. And looking at the pre-sentence report, this defendant has an arrest on September the 3rd, 2004, out of Malibu, California. He was convicted of trespass and disorderly conduct of fighting. He was sentenced on July 16th, 2007 to a 3-year period of probation.
What? I gotta go.
The next contact.
No, I gotta go. Go to pee my pants.
I'm sorry, Judge. He has to
I
go
have to
use
go in the bathroom.
One moment, okay, let's stop.
So sorry. He had to use the restroom.
All right, we're good.
No worries. No worries. Yes, we will pause the record.
I just took my camera off. The reason I can't look at.
All right, so they're waiting for Mr. Busey to get back from the bathroom. You saw him say, look, I have to go. It's interesting because the judge had concerns previously at his previous hearing and postponed the sentencing to today because she was concerned that he wasn't competent enough. He had shown signs in the previous hearing that he didn't really know what was going on. Today, he seems to understand what was going on. But as you can see right there, he had to go to the bathroom. So they're pausing the record for a second so that she can continue to give him a sentence. And she was beginning to read through some of his background. And he has a number of contacts with the criminal justice system. Let's bring in our guest. Joining us now to discuss, National Trial Attorney Michael Javer. Michael, great to see you. Thank you so much for joining me here on the program. And you know, it's a bit of a sideshow here. This is sometimes the way the criminal justice system works. She had concerns previously that, again, as I mentioned, he wasn't competent. You heard his attorneys making the argument that he's had some issues. You know, he had a very bad motorcycle accident, made all the newspapers back in the day. I think it was the late 80s. He was in a coma for a while, still struggling with some mental health issues, but he was found to be competent. What do you make of what we're watching right now?
I like the way you framed it, a sideshow, because from my days as a public defender, pretty much every day was a sideshow. And so this is not unfamiliar to me, his behavior. Believe me, these judges have seen many, many, many worse. This judge particular sees misdemeanors, which means she sees all kinds of character come through her courtroom. She's handling it well. She's handling it with grace. If that judge did not believe that he was having competency issues, she would have reacted much differently. She would have put him in contempt. She would have asked him to surrender himself to authorities. But I think that this judge believes that he doesn't know what's happening and that he has these competency issues. So I believe that it's a sideshow, like you said. We'll see what happens.
Yeah, and again, he's much better this time, Mike, than he was the last time. Last time, he clearly didn't understand what was going on. Couldn't hear. He had a number of issues. At least now it looks like he kind of understands what's happening, able to answer questions. Last time, that was a struggle as well. I want to talk a little bit about the arguments being made by his attorney. He's trying to keep him off probation. For whatever reason, doesn't want him to have any sort of control by the system. It's understandable, right? He's 81 years old. He talked about his mental health issues. Talked about this happened in 2022. He's been good since then. Talked about and no real significant contact with the system since about it, from what I could make out from his record, since about 2011 or so. He had some sort of domestic violence issue. Actually, it was a sexual assault, or at least a claim of a sexual assault for an employee on The Apprentice. That show that was a big hit back in the day. What do you make of their argument, trying to keep him off probation? What do you think the judge might be looking at in making this decision?
The judge is going to have to put him on probation, but the defense attorney had to make the argument for him not to be on probation, because as a defense attorney, you always know your customer. He knows that this defendant is going to fail on probation. That video of that gentleman who attacked the judge in Las Vegas, that was a show cause hearing because he had violated his probation. Defense attorneys know which client is going to violate probation. So this defense attorney is working hard to keep him out of it, because if he's not, he's going to be show caused every other month to come in front of this judge and appear. why your client did not follow the probation.
That's interesting. So he's actually making the argument, Mike, that because he's 81, because he's got these physical and mental health issues, because he's not going to be putting himself in the position he was when he committed this particular offense. He's not going to go out and do these sort of shows or whatever they do when they go out and make a few bucks, that he's not at risk for reoffending, right? That's really the argument he's making. But you're claiming he knows that there's a likelihood he would reoffend and he'd be dealing with this on a constant basis.
If he and I were having a beer, we would tell each other the same thing, me and this defense attorney. 1,000% he's going to violate the probation every other month. And that's why he's doing it. He can't say that to the judge. But between you and I, that's why he's fighting so hard.
Fair enough. I mean, you know, he could be going out to the grocery store and find himself in a situation where he's doing some sort of, you know, sexual contact. So it is a serious concern. I mean, we're making light of it, but it's a serious concern. Yeah. All right. I want to take a break here, Mike. Stand by. When we come back, the sentencing hearing for actor Gary Busey continues. So keep it here on Court TV Live.
It is my understanding you wish to plead guilty to a fourth-degree sexual contact, criminal sexual contact. Is that correct?
Am I pleading guilty?
Yes.
No.
Yes.
Okay.
I am?
No.
Okay.
No, that's not how it works. Listen to me, Mr. Busey.
Huh?
Did you talk to your attorney about how you want to handle your case today?
Yes.
Yes.
Welcome back to Court TV Live. I'm Michael Ayala. Now, that was some of the stuff that made the judge concerned about whether he understood what he was doing. And we are bringing you today the sentencing hearing for actor Gary Busey. Here you saw he pleaded guilty in July to inappropriately touching a woman while she was taking a picture with him at the Monster Mania convention in Cherry Hill that happened back in 2022 in New Jersey. Now, Busey was there to make a guest appearance at the event. So we want to get you back to his sentencing hearing that's happening via Zoom. Now, it was put on pause while Busey took a bit of a potty break, but he's back now. Let's get you back into the hearing.
Very good.
Okay. We'll continue with your sentence. The next contact that Mr. Busey had with the criminal justice system was an offense date of 12/16 the year 2000. That contact was out of the state of California. He was convicted of a hit and run with damage to property. He was convicted of that offense on August 3rd, 2021. He was given a 1-year period of probation.
What was that?
The police car.
Huh?
The hit and run. It's over.
Now, are you able to hear me, sir?
Are you able to hear
Can you
her?
hear me?
Can you hear her?
What?
Are you able to hear me?
Yes.
And whenever you cannot hear me, let the person know sitting next to you, and I will repeat myself, okay?
Yes, ma'am. It'll be done.
Yeah. I have reviewed the criminal division pre-sentence report. And I do find, as I said, that this defendant has had prior contact with the criminal justice system. Now, with this indictable conviction, I've looked at all of the aggravating factors, 1 through 15. And I do find that number 3 is applicable when I look at his contact with the criminal justice system. I find aggravating factor number 6 is applicable based on the extent of his criminal history, which I have placed on the record. And I find number 9 to be applicable, and I place great weight on the need for deterrence.
What?
I am now looking at the mitigating factors. The defense have asked the court to find the following mitigating factors. The defense has asked the court to find mitigating factor number 1. what says the defendant's conduct neither caused or threatened serious harm. I think someone similar sexual contact can threaten serious harm, so I do not find number 1 to be applicable. The defense have asked for mitigating factor number 2. Whereby it says the defendant did not contemplate his conduct will cause or threaten serious harm. I do not find number 2. You have to contemplate when you are touching private areas of anyone that can cause or threaten harm. So I do not find number 2. I've looked at the mitigating factors 3, 4, 5, and 6. They're not applicable. There are no facts to support a finding for those. I do find number 7. Although this defendant has 2 convictions, he has had a law-abiding life overall. So I do find number 7 in his favor. I've looked at number 8. I do not find that there's enough in front of me to support a finding for number 8. I do find number 9 in mitigation, as he is under treatment with his doctor. So I do find number 9. I do find mitigating factor number 10, as I do think he is a candidate for probation. Looking at aggravating factors 11 through 14, looking at mitigating factors 11 through 14, those mitigating factors are not applicable as there are no facts to support a finding for 11 through 14. When I weigh the aggravating and mitigating factors on a qualitative as well as a quantitative basis, I do find that the aggravating factors outweigh the mitigating factors. This was a negotiated plea agreement between the prosecutor and the defendant. In deciding whether or not to accept the agreement, I have considered the nature and degree of the crime, the need for punishment and deterrence, the defendant's prospects for rehabilitation, the pre-sentence report, the defendant's previous involvement in the criminal justice system, the recommendations of the prosecutor and the probation department, the terms of the agreement and the interests of the public. The agreement appears to be fair in the interest of justice, and the court sentences the defendant as set forth in this judgment. Now, Mr. Busey, sir, if you violate your probation, you can receive up to 18 months in state prison if you violate probation. I have considered argument of counsel under State v. Warren, whereby the defense is asking the court to impose fines only in this case. I find that the defense has failed to meet their burden. I find that this defendant shall be sentenced in accordance with the plea agreement.
What?
I find that the defense has failed to meet his burden when I weighed the aggravating and mitigating factors. That fourth-degree criminal sexual contact is a serious offense. And I find that I have not heard anything that will warrant this court to go against the plea agreement as entered. Now, the defendant's exposure for probation is anywhere between 1 to 5 years. The court is to start at a mid-range period, which will put him at 3 years. When I do look at the mitigating factors that I have found, I consider his medical history, I consider his age, In the interest of justice, I am sentencing this defendant to 2 years probation. Defendant shall provide a DNA sample. His fine shall be $50 VCCB, $75 safe neighborhood, $30 law enforcement, to be paid at the rate of $20 per month. There's a $5 probation supervision fee. The only condition on placing, sir, is that you have no contact with the victim with the initials of AD. So it's clear for the record, Mr. Prosecutor, I reviewed the impact statement from the victim with the initials.
All right, so she's getting into the impact statement. She said she's sentencing him to 2 years probation. She weighed the aggravating and mitigating factors, decided the aggravating factors outweighed the mitigating, and he had to do some probation, 2 years. All right, we're going to pause it right there for a quick break. When we come back, we're going to wrap up the sentencing. So keep it here on Court TV, your front row seat to justice.
Young mother found brutally murdered.
Now the victim's boyfriend, a married father of 4,
is charged for the murder of his alleged mistress and her unborn child.
The pregnant mistress murder trial. Live coverage today, only on Court TV.
Join me for a Court TV true crime series.
I've never seen anything like this.
This was a whole different level.
Victim to Verdict with Ted Rollins. Season premieres September 27th.
Only on Court TV.
The case has been delayed for various reasons having nothing to do with the court or defense counsel, in that we're in 2025 now, but during that period of time, the 3 years, Mr. Busey has not engaged in any behavior that would indicate he needs any type of probationary supervision. So again, I haven't stated much about Mr. Busey's life, but he is obviously a recognized public figure, has had substantial success in the acting industry, is a well-known individual, and unfortunately, because of that, I'm sure he would not want to give up any of his public persona, but he has engaged. One of the deterrences for someone like Mr. Busey is the substantial adverse publicity that attends to being in a proceeding like this. To me, that's a measurable penalty also, and I think it factors into the suggestion that he will not violate the law.
All right, that was Busey's attorney, and we are wrapping up our coverage in the sentencing of actor Gary Busey. I want to get you back now as the judge wraps up her sentencing.
Consider that in my sentencing that I've imposed. As a summons 2022-1175 out of 0412 that's dismissed. The remaining counts of the indictment, 2, 3, 4, and 5 are dismissed. I am advising you, sir, of your appeal rights. You, sir, have 45 days to appeal this sentence today. Do you understand that?
You have 45 days to appeal the 2-year probation sentence.
Yes, I understand.
Now, if you cannot afford a private attorney to file your appeal, you can write a letter to the criminal division manager. If you qualify for representation, an attorney will be appointed to you. Do you understand that?
Yes, I do. Thank you.
You also, sir, if you were to miss that 45-day deadline to file your appeal, you could seek a 30-day extension to file your appeal if you could show a good reason for missing the original deadline of 45 days.
What? But
If you
she had
wanna-
her hand in front of her.
Can you repeat that, please?
Yes, I can. If you were to miss that 45-day deadline to file your appeal, You can make a request for a 30-day extension to file your appeal. Do you understand that?
You could request 30-day extension.
What?
You can request a 30-day extension for an appeal if you choose to file an appeal. Past
Okay,
45
yeah, I understand.
Now, if you miss that 30-day deadline, you can lose your right to appeal. Do you understand, sir?
I lose my right to what?
Appeal.
Yes, I understand.
Hey, Joey, take the other person out my booth. I don't want anyone in the booth, but who's supposed to be in the booth right now? Do you understand that, sir?
You said yes.
Yeah.
You already said yes.
Yes, I do.
Now, I want to tell you about what's called your post-conviction relief rights. You have 5 years from today's date to file a petition for post-conviction relief. Do you understand that?
Yes.
Unless there is an exception under the court rule 3:22-12. Do you understand, sir?
Yes. Yes, ma'am.
Okay, now did your attorney in the past review with you your appeal rights that I've just read to you?
Did your attorney review this with you? Your appeal rights?
Okay. Yes, I did. Yeah. I will follow the advice of my attorney.
Say it again, sir, please. I'm sorry. Excuse me.
What?
She wants you to repeat it.
I will follow. Read that writing. I will follow the advice of my attorney.
Okay, but I just explained to you your right to appeal. Do you understand what I just explained to you?
Say that again, please.
I just explained to you your right to appeal the sentence. Do you understand those rights?
Do you understand the rights?
Yeah. Yes, I do.
Okay, based on what you stated, I am satisfied that you understand your appeal right and it's time to file a post-conviction relief application. Now, so the record is very clear. I have been making observations of this defendant so that the court is satisfied that he understands everything that is happening.
Thank you, ma'am. Yes.
I have requested medical documentation that says Mr. Busey understands and that he's competent, and I have received that documentation. So I am satisfied that he understands.
Thank you.
You're welcome, sir. Well, with that, court is complete. Mr. Busey stated,
All right, so the judge making sure to get on the record that she got documentation that he is in fact competent. I mean, he seems competent today. 2 years probation for Gary Busey, $50 fine, no contact order with the victim in the case.